indicated by previous speakers when we talk about mobilizing the resources, and you have indicated it in your last.
IDLO is pleased to welcome Dr. Willy Mutunga, the Chief Justice of the Supreme Court of Kenya, with us today for our Assembly of Parties 2012. What does the rule of law mean to you?
Well, I think when we talk about the rule of law, my starting point is always to look at the opposite, and people say it's the rule of the jungle, and people get a fairly good idea about the reasons, behind the rule of law. But in my country, I always ask people to look at the supreme law, which is the Constitution. And you then define the rule of law from that perspective, which is basically how you implement the Constitution, how you respect it. And within that, then people come to see whether the law actually acts for them, or against them. Because you are now going beyond the rules and the procedures. You're going through other important aspects. Like IDLO mentioned human rights and other aspects. So you have a broader definition of it. But for me, the most fundamental issue about the rule of law is that the people must accept that the law is fair, impartial, and that the law is not just for particular interest groups or social groups or classes. It's something that they can own. And that way people, will respect it. If that doesn't happen, then people will see the law as oppressive, as exploitative, as dominating, and they start saying, as usual, this is not the law for the poor, and they extend it to the judiciary and say the judiciary is not for all Kenyans, it's for a particular group of people. So I think it's a broad definition, and it's not static. It's something that has to be revisited as you implement specific laws. If it's land, again, different perspectives have to come into it. If you're talking about industrial jurisprudence, where people can actually say this law protects employers, and not workers. If it's an environment, still the common denominator is, can somebody say that this law is for everybody, or is it just for certain vested interests?
How much of a change can people like you make coming from civil society?
I think when you come from civil society or from organizations that agitate for change and organizations that have thought through what changes should be, you try as much as possible to implement that vision. And coming from the civil society myself, I was quite certain that when I went to the judiciary, I would change it. Because I knew, what the problems were, those who were going to resist, change. Because from the civil society, we had done a lot of work on institutions and state institutions, and we knew that there was an issue of leadership, and so I got into a position of leadership, and I was quite aware of who would resist. And I was also very aware of how strategically I should implement the reforms from the margins, because if you get into the center, you can't implement anything. And I also knew that they had done so many reports and recommendations, but they didn't have the political will to implement them. So when I started implementing them, I kept on telling them that these are your reforms, they are not mine. So I think civil society groups provide you with a lot of thinking, a vision, a lot of research and knowledge, and also a group of people you can go back to so that you don't feel alone. In my case, I still got those networks, and they have been very helpful.
How much resistance did you encounter from the system?
You mean within the judiciary?
Yeah.
First of all, the judiciary is like a convent next door. What is called judicial culture is very, very, very conservative, because it's the way judges do things, the way judges think that they are entitled, and magistrates, and so the first debate I started in the judiciary is about judicial culture, that judges and magistrates can have an eye contact with parties, they can, greet them. After all, they are paid by the taxpayer. The issue of dress and undress also became important in terms of just how you relate to people, how you relate to the lawyers. So those were just the little things. Asking judges to know the names of the women who make tea, sharing the corridors, because I got to the judiciary and I found that judges don't share the corridors, although they are very broad. Once they are walking on the corridor, everybody has to stop, stay out of the judge's path. So it was very, very, very colonial, actually. I didn't realize how conservative judicial culture was. And of course, that came with, judicial impunity. People thinking that they can stop proceedings whenever they want. They don't have to go to court, every day. And that explained the backlog of cases. So that in itself is based on vested interests. And once you start telling people now you've got to change, they then start resisting. But initially there wasn't much, because those were the soft issues I was dealing with. But as we started now dismantling the corrupt networks involving advocates and the judges, then the reforms began to bite, and the people started now to resist, because there were people who were making a lot of money out of the procurement. Judges, I told judges that they could not be now part of procurement committees and tender committees, because they were hired to hear cases and not to run the judiciary. So delinking the judiciary from the administration created a lot of resistance. And then I wanted the judges, especially the Court of Appeal, to be decentralized. But they were making a lot of money, going from one region to another. And their drivers, their secretaries, and everybody. It was kind of a gravy train. So when I said now we would decentralize, there was a lot of resistance. That hasn't happened yet. So my strategy has been to move from the margins, move towards the center. But as you get to the center, you realize that you're also fighting people outside the judiciary, because those cartels are internal and external. And so you get the politicians now coming out to say, well, this judiciary is activist, this judiciary can't be trusted. And that's where we are at. Nothing that surprises me, because I knew all this would happen, yeah.
You mentioned yesterday that one of your first acts as Chief Justice was getting rid of wigs and His Excellency titles in the judiciary. That was another thing, like the judicial culture, like you were saying.
Yes, it was part of that. I was, as an advocate, I always hated wearing wigs, because first of all, they are very uncomfortable, and the robes are heavy, and in hot places, it's very, very uncomfortable, to wear them. But what I did was to persuade them. I wrote a paper, an article on the history of wigs and robes, in the UK, and how a lot of jurisdictions are not wearing wigs anymore because the judiciaries want to be pro-people and not to be aloof, and how dressing is part of that, and how our robes are part of the colonial history. Kenyans had made it very clear when they changed the constitution that we should wear, robes that reflect our new constitution and whatnot. So it was basically saying that dressing and how you are dressed is part of that culture that we needed to change. And luckily, the judges also are fed up, with the wigs. So we ended the wigs. The issue of addressing judges, because if you're in the High Court, you'll be called, my Lord Chief Justice, Your Lordship, Lady so and so on, Lady Justice and whatnot. And as I said yesterday, the Christians were very angry with, people being, Your Lordship, because they believe that there's only one Lord, and that's Jesus Christ. So, but for me, it was the whole question of equalization. I wanted the magistrates, any judicial officer, to be called Your Honor, right from magistracy to the Supreme Court. And the other thing we are doing now is to look at the buildings themselves and the courts themselves, because if you have been to our courts, the judges show how aloof and inaccessible they are, because the lawyers sit very far. If you have no public address system, they will not hear what you are saying. And the building itself is not well lit, so it's, intimidating. So we're also working towards changing the courts themselves so that they can, reflect that accessibility, that fairness, and because I think it's important. We got that from the South Africans, because the South Africans thought through their court systems and what courts should be like if they are going to be people's places. But there are still some judges who tell people that they should be called my lord and what have you. One judge actually told me that he had been called his honor as a magistrate, for so many years, and now that he has been promoted, I say he can't be called his lordship. So it's a struggle, but as long as people see it from the perspective of changing a culture and being people-oriented, they will have to change, because the Constitution now says that we get our monies from Parliament. And if Parliament doesn't give us money, we are in trouble. And the best way to get that money is to make sure that people can fight for us when Parliament tries to starve us of resources. Yeah.
Can you already measure whether people's confidence in the judicial system has improved?
They had what I call what do they call it? The polling. Yeah, where they had that, and I think we had moved from 30 to something like 70%, just in terms of people being asked whether they think that the judiciary is changing. And I think a lot of it was simply because within a few days, people found magistrates who would talk to them. People found that the toilets, we had public toilets which people could use, which had been closed and occupied by just magistrates and judges. Little things. If they were paying fines, we quickly made them pay through SMS instead of waiting in the courts for a long time and being subjected to corruption. Very, very, very small things that people saw as part of that change, yes.
To what extent do you think Kenya can be a blueprint for other countries, not just in Africa, but around the developing world?
Yeah, that's a great question. I think the only way we can do that is through the way we interpret the Constitution, through the nurturing of our own jurisprudence, the way we decide cases. Because if, as I was saying yesterday, if our Constitution is the most progressive, if Bill of Rights the most modern, so the way we interpret those the Constitution and the way we come up with the decisions, that is important because it can be borrowed, by African countries and also other countries in the world. Just the way we borrowed it from India and Colombia and South Africa. So my vision is to extend that because it's already happening. People are already borrowing what has been decided in India, Colombia, and South Africa, and Venezuela, and other places. So we can be, we can be part of that because I think jurisprudence is about creating a better world, not just for Kenya, but everybody else. Yeah.
Thank you. And finally, do you have any words for IDLO staff or alumni?
Yes. I think IDLO has a great niche in their work in Kenya. You picked the implementation of the Constitution, which I think it's the burning issue, in that country. And by giving capacity to the lawyers, to the judiciary, to the civil society, and working around that theme, I think it's great, and I look forward to the collaboration and rethinking of your projects in Kenya.
Thank you very much.
Thank you.